The Commission for Gender Equality has hailed a court ruling that pertains to parental leave. The High Court in Johannesburg this week declared unconstitutional parts of the Basic Conditions of Employment Act and the Unemployment Insurance Fund Act because of discrepancies in the allocation of maternity leave. The law currently unfairly discriminates against mothers and fathers, surrogate parents, and those who adopt children. The court ruled that any parent is entitled to 4 months parental leave. So to get more of an understanding of this, perhaps how this new ruling will also be affected, we're going to be joined via video link by legal analyst Elton Hart. Elton, good afternoon, and thank you for your time with us here on the SABC.
Good afternoon, Lisa, and good afternoon to the viewers.
Elton, the crux of the matter, unequal treatment of persons. What are your thoughts on this ruling challenging the country's labour laws?
No, indeed, it's going to have significant importance, especially for employers, because you will find and this is now, mothers normally gives birth to children, and their bodies undergo certain changes.
Elton, I'm just going to ask that you listen to me directing the question. If there's any other noise, don't worry about that. I'll lead you. Please continue with your answer.
Yes, because now mothers normally go and there's a biological change in their bodies, and I think they need time to actually recover. However, our constitution is written in a certain way to say every person is equal before the law, but obviously now this will have an effect for employers, because now you'll have more male persons that is fathers, biological fathers to children, that will also now look to have a longer leave period, and that will mean that you have to now bring in alternative employment, and that can also have cost implications for the employer. And that at some stage people will think that if a person's wife is pregnant, and then they will start now asking you in your interviews, is your wife pregnant? And that might have some privacy issues. So I will still see how this will be practically applied in our country.
Well, speaking about practicality, what's also next? Just on the back of what you echoed, the effects that this ruling is going to have for parents or guardians going forward. Can the Minister of Labour appeal for leave to appeal? What's the impact of that option as well?
Obviously, it was the High Court giving a judgment, and then you can if a court gives a judgment and you feel like the judgment is unfavorable to you, or you disagree, or the court is maybe misplaced in its judgment, and it was now Judge Sutherland that gave this judgment, they can now appeal to the full bench, which would be 3 judges sitting in the High Court. If they are still not happy with that ruling, they can then take it to the SCA and also eventually to the Constitutional Court, because there is a constitutional aspect that is captured in here pertaining to Section 9, equality of all persons before law. So there is remedies at the Minister's disposal.
Elton, thank you for that context. I just wondered at this point, given the implications, if the Act also requires employers to pay any remunerations whilst one of the parents are on leave, what are some of the other non-discriminatory, more inclusive terms that we'll now have to use? Perhaps, I'm assuming maternity leave won't suffice.
No, it's not. I think, of course, we talk about maternity, paternity. Now you'll have to most probably say that this is like family responsibility leave, where you can actually bring it both under the umbrella, and then family responsibility leave will be thrown right open now, because family responsibility can relate to death of a family member. It can maybe be sickness of a family member. So then this birth can also be brought under that umbrella, to say even adoption and would be in that captured in that umbrella. And I think that maternity leave should be now then disregarded if one look at it like this.
Absolutely. I wonder at this point, what are some of the other more innovative approaches to improve reconciliation between work and family life and maternity protection, if we're still going to use that umbrella term, given what has emerged and how we proceed from here on to?
Now, obviously, because the court has made a ruling and it's not final that this is now how it's going to play out, of course, what if the High or the full bench come and say, but High Court, you were misplaced in how you interpret the law, this can never be, because then they can look at different other things. But obviously, when the parties actually presented the case, now the problem might be that the minister is restricted to the appeal record. He cannot now introduce new evidence when he takes on appeal. All the points that was canvassed, and I think now he's already boxed in. So this is now how guidelines and regulations for labor law would be now put in place to make sure that we can actually now go with this judgment if it's not overturned.
And Elton Hart, just to an earlier point you alluded to, but I want to look at the macroeconomics at this point also given the current global economic crisis, how this has impacted on maternity protection, paternity protection, and really what this also means for South Africa at large.
Now, obviously, when our constitution is written in such a way that we say we need to develop our law in line with international law. And in international law, if you go look at standards internationally, that parents are afforded more leeway pertaining to birth of their children, illnesses of their children, and how parents are treated in terms of taking let me now use the new word that I said, family responsibility, the broader term. They are treated different, and we in South Africa, we still had like a more maternal approach compared to a inclusive approach for both mother and father, or grandmother and grandfather, that type of situation.